countdown.
Hello, everyone. Thank you so much for joining me on this Thursday. I'm still trying to figure out this StreamYard, but thanks so much for joining me. I am going to show a lot of documents, and so that's why I decided to figure out this StreamYard, and maybe I can utilize it better the next go around. But I did want to talk about what new documents that I received, and a lot of it that I'm going to speak about today is about the CODIS matches. I do want to just mention that, I welcome all discussions about this case, but please no bashing, no name calling or trolling. And I do have mods right now. And so if you get a warning, please just don't do it again. So I'm going to first look over my notes real quick and just talk about a couple of things. So the prosecution case against Barry Morphew relies heavily on his motive to harm his wife, Suzanne, the opportunity he alone had as he was the last person to see Suzanne alive, and the inconsistencies in his statements to law enforcement, and the ultimate cover-up he perpetrated the day after and in the following months. Now, the Morphew's defense say there's no body, no confession, no eyewitness testimony, or physical evidence that Suzanne is even dead, that there was even a murder, and that Barry Morphew is held responsible. So let's first talk about the CODIS hits that has been discussed a lot in court. I got a couple of motions that I want to discuss. I do want to mention that the murder trial for Barry Morphew is set to begin April 28th. It won't likely, the first opening statements won't be on April 28th. They'll still do jury selection then. And then whenever jury selection is over, then they'll go into opening statements. Okay. I am going to figure this out, and we are going to, I'm going to try to share my screen so you guys can see the documents that I'm referring to. Bear with me. This is the first time I've done this. So, okay. Okay. Let me make sure you guys are seeing this right. Uh-oh. I should do that. You guys are just seeing a black screen, aren't you? Okay. Nope, that's the wrong one. Sorry. Okay, sorry, guys. Okay, so this is a motion filed by the state, by the prosecution, and it was filed April 5th. And it's a motion in limine. So it's the people's motion filed 46. So this talks all about the CODIS matches. So on May 19th, 2021, Megan Doogie sent a letter to various law enforcement officers notifying them of a CODIS match on the swabs taken from Suzanne's Range Rover glove compartment. This letter was the result of a keyboard search and indicated that there were 3 matches of, in quotes, limited genetic data. These matches came out of cases from Chicago Police Department, Tempe Police Department, and Phoenix Police Department. It should be noted that these matches were for unknown DNA in cases in those jurisdictions and not to specific suspects in those cases. Okay, I don't know why it went from, let me make sure you guys can see it full. That's what I want. Okay. Okay. So the whole CODIS matches was talked about heavily in the preliminary hearing. All of the investigation radar stop. Sorry. Since the preliminary hearing, law enforcement has conducted more investigations on those CODIS matches, which they all provided to the defense. Linda Stanley says, the district attorney says, our investigation has excluded all three. And then it goes into the specific cases. Sorry, guys. Dax, radar, come here. Okay. Let me go to my notes real quick. Okay. So this alleged sexual assault happened in Chicago in 2004. The alleged victim admitted themselves to a hospital in Chicago. You can see this hospital name right there, saying she had been sexually assaulted walking down the street by two men who came up behind her and hit her on the head. According to this court document, one of the victim smoked crack and engaged in consensual sexual intercourse with an acquaintance named Munchie, nicknamed Munchie, then reported that she had been sexually assaulted in order to avoid problems with her common law husband. But I'll show you Exhibit 1. So this is actually the police report from the incident in Chicago. Let me explain it to you in further detail. Okay, so this police report was from Chicago, a sexual assault case. This again was filed April 5th, 2022. One of the partial CODIS matches was identified belonging to a man belonging to a nickname Munchie. His DNA was collected as part of a rape kit performed in October of 2004. Munchie was not actually a perpetrator involved in a sexual assault. However, the woman whom he had consensual sex with had lied and claimed she was raped by an unknown person. According to details released by the investigating police department, the victim was a crack cocaine user who had just had a baby 2 months prior. She had left home to meet up with friends to drink alcohol and smoke crack cocaine in the rear of an abandoned building. She was gone from home for 2 days and came up with this rape story to cover for the fact she was missing for 2 days. The woman later confessed to the false report. Charges were never filed against Munchie, the man. This case is considered closed and resolved. There's no unknown perpetrator linked to this specific lead. So here's the part where it says who had a 2-month baby. You can see there's some information redacted off of this. So you can see at the end it says, this case be unfounded. Okay. Let me know if I go too fast with these documents. I can go slower. Okay. Now this is this is a report, a supplement report from CBI in regards to the Chicago CODIS match. And so you can see back and forth communication from investigators about this CODIS match. And this was dated November 29th, 2021. So Agent Derek Graham and Megan Doogie are having conversations about this CODIS match back and forth. She spoke with a forensic scientist in Chicago about this as well. Her name is Karen Abenati. I'm probably butchering that name, but they found that there was actually 2 munchies in the Chicago area. So this shows that Derek Graham followed up with the Chicago CODIS match, or CODIS lead, excuse me. Derek Graham sent an email to CBI CODIS administrator in Colorado, Megan Doogie, requesting contact information for the Chicago, Illinois CODIS administrator. And you can see their responses here. So it looked like they went back and forth on November 29th. And again, this is a follow-up on the DNA sample from Suzanne Morphew's glove box. So Agent Graham even makes a telephone contact with forensic scientists in Chicago. Graham is asking for information regarding a person identified as Munchie, who is the person the police reports Chicago PD says this DNA belongs to. He provides her with 2 possible names for this person that were provided to him by Chicago PD. She runs a search. This is the person who is in Chicago with the CODIS administrator. She runs a search and cannot find a sexual assault related to the specimen ID number provided by Graham. Graham then calls the CBI CODIS administrator in Colorado, Megan Doogie, to confirm the specimen's number. She provides him with the correct specimen number. She then runs a search for 2 names provided to him by Chicago PD. Agent Graham then calls Chicago. Okay, one name is in CODIS and the other name is not. The Agent Graham then calls Chicago PD Sergeant Patrick McGarry. McGarry explains that the 2004 sexual assault linked to Munchie is unfounded. McGarry then directs Graham to make contact with the female who reported the sexual assault. McGarry then explains that the female had falsely reported a sexual assault because she wanted to go smoke crack cocaine and she was a documented prostitute. McGarry then searches the 2 possible names for Munchie and that both men were in CODIS. One of the men's names was actually a variant spelling with 2 T's of the name provided. One man had a previous warrant at one time and the other was previously arrested for narcotics and prostitution. After receiving this information, Agent Graham then calls Agent Doogie back to update her about, what he did and what he investigated, to check on the variant spellings to see if she could find the 2 profiles to make a comparison. Megan Doogie informs Derek Graham that since both men are in CODIS, then they could be excluded as contributors to the DNA sample from Suzanne's glove box. So the Chicago lead is now ruled out. Does that make sense? So what I just summarized kind of what this document is saying. So you can see Sergeant McGarry, conversations, telephone contact, is everyone okay with the Chicago DNA? Does everyone understand that? If you have questions, now is a great time to ask them about the Chicago DNA partial match. So this is this is like a call log or like communication log between CBI investigators as well as the CODIS administrator in Illinois, and then Derek Graham, the CBI agent as well. I'm not understanding why. Why what? I'm just explaining kind of how investigators are excluding these 3 CODIS matches that they got. So this is the explanation to what happened to the Chicago, Illinois CODIS match. So there wasn't really a sexual assault suspect that was running around in Chicago. It was a woman who didn't want to disclose that she had consensual sex with this person nicknamed Munchie. And so she made up this rape story. And so that's where this. Okay, so I'm going to move on to now the, I can explain. I don't think I read this part. Through the investigation of Colorado Bureau of Investigation agent Derek Graham, he was able to track down that there are 2 men with the nicknames of Munchie in Chicago police files. Further investigation revealed that both men were in CODIS when Agent Graham talked to Megan Doogie and the Colorado CODIS administrator. She told him these Munchies, the 2 men, were in CODIS and that they can be excluded from the unknown DNA on the dashboard. So now let's move on to the Tempe, Arizona case. Okay. In 2000, the victim in the case was walking from where she was staying at a Motel 6 to a convenience store. Before she could get to the convenience store, an unknown suspect assaulted, raped her, and fled. When she was able to get to the store, she called police. A rape kit was done. The case was suspended when law enforcement could no longer get in touch with the victim. And then see exhibits 3 and 4. I will get to that in a bit. The investigation of Agent Graham revealed that the unknown DNA found in the victim was entered into CODIS. According to CODIS administrator Megan Doogie, if the information was entered into CODIS, this suspect can be eliminated from the unknown DNA on the glove compartment. Let me make sure my notes are all scattered. That was exhibit 2. Okay. So there is a connection between the Tempe case and the Phoenix case. So I'm just going to go ahead and talk about the Phoenix case, and then it will make sense about the Tempe case, if you guys understand. Okay. This is the Phoenix Police Department case. Again, this is a motion filed by Linda Stanley. So this is information from the prosecution. In 1998, the victim was telephoned by her former boyfriend who asked her to come to a place he was house sitting. She went over and they started talking. When she told the person, the former boyfriend, that they were not getting back together and she was going into the Marines, he got angry and hit her. Then he raped her. And then when he stopped raping her, the victim was able to get to the bathroom and put her clothes back on. So then she fell asleep in the place that she was at. And when she awoke the next morning, he started raping her again. And I should have put a disclaimer. I'm sorry, this is pretty graphic information that I'm about to talk about, this Phoenix rape. She then convinced him to take her home. At home, she called her sister and another former girlfriend of the suspect, who took her to the hospital where a rape kit was done. The case was suspended when law enforcement could no longer contact the victim. Although the DNA profile from the rape kit was analyzed and put into CODIS, a DNA sample was never secured from the suspect to compare it to the profile from the rape kit. the profile was not in CODIS. Investigators from Colorado were able to track down this person who referred him to his attorneys. So, the investigators in Colorado tracked down this person. That person says, hey, I don't want to speak, talk to my attorney. When prosecutors contacted the attorney, he only said so-and-so had no connection to Colorado and would give no further details. Well, Agent Graham went one more further and was able to secure a DNA sample through a court order. And the DNA analyst excluded this suspect as a contributor of the unknown DNA found on the Range Rover glove compartment. Now I'm going to go over the exhibits in this about the Phoenix. So this is the police report from Phoenix. Let me make sure I'm showing the first one because there's... Okay. Okay. So this police report is from August 15th, 1998. Victim states that she was allegedly sexually assaulted orally, vaginally, and anally. In addition to assaulting her by striking her with a closed fist, the victim was processed with the sexual assault kit for bodily evidence. The suspect was known to the victim. The victim stated that she had been sexually assaulted numerous times in the previous 4-year period. The suspect and victim had previously been involved in a relationship. She had met him at an address where he claimed he was house sitting for a friend since he had been kicked out of his home. He told the victim he was leaving in January, or she told the victim, he told the victim he was leaving in January to go to the Marines. After some time, the suspect became upset, and when the victim tried to leave, he made the statement, "You're mine and you're not going anywhere." So I'm sorry, I said that wrong. The woman, the victim, was going to be going to the Marines in January. The victim reiterated that she was leaving him and moving on with her life when the suspect said, "Don't raise your voice at me," and struck the victim in the face with the fist of his right hand. The victim then hit the suspect with her left fist. I'm trying to get to the part where... Okay. You can read here, going to the Marines. She reiterated she was leaving and moving on with her life. "Don't raise your voice at me." Okay. The suspect then pushed her into a table where the victim hit her head and momentarily blacked out. When she came to, she was in a dark room. The suspect physically assaulted her once more, then said, "Get up here, B, you effing whore." Sorry, I'm just trying to read this. As he pulled her up on the bed, unzipped his pants, and then forced the victim's head to his penis, where he forcibly inserted it into her mouth. The victim said there was a gun and a knife visible in the room, so she relented and stopped fighting because she feared for her life. Was in danger if she continued to try to fight him off. He sexually penetrated her vagina while she was screaming. Could feel okay, I'm not going. It's very graphic. I just will stop there. You can read it for yourself if you want to. It's pretty bad. Okay. While I do not know the outcome of the arrest or conviction because it's not provided in these documents that I received, the fact of the matter is this suspect is known. It's a known person to this victim, and her identity is not known to law enforcement, and the suspect's identity is known to law enforcement. So this case is solved. And again, this is the Phoenix police. This is the Phoenix match. Okay. Talked about this. Okay. And then let me show you. This is, oh, this is about the Maryland one. Hold on. Okay, so here's just photos of the Suzanne's Range Rover. This is the glove box, if you can see what I'm talking about. So this was the area that was swabbed with 3 matches that we've been talking about. You can see it's parked in the garage. Okay. Does anyone have questions about the Phoenix? The Phoenix match. Does anyone have questions? I'm still trying to figure this all out. Someone's asking if we are talking about the DNA that was found in her car. Yes, we are talking about the DNA found in Suzanne's Range Rover. Okay. Any other questions? I'm looking at the comments now, sorry. Are we ready to move on to the Maryland one? Okay, it looks like we are ready to move on to the Maryland. Okay. All right, so back to the People's Motion 46. Okay, in one of their pleadings, and they're talking about the defense's motion, or in one of the pleadings, the defense indicated that there was an email from CBI indicating a CODIS match for the unknown DNA on the glove compartment out of Maryland. This was not a CODIS match. If it were, it would have been included in the letter from May 19, 2021. According to Megan Doogie, as a result of her keyboard search, she received an email from her counterpart in Maryland. So this is, again, Maryland investigators are now reaching out to Megan Doogie, saying they have an association between the profile on the glove compartment and a candidate profile from Maryland. When Ms. Doogie asked their agency to rerun the candidate profile to get more information to either exclude or include the profile, she was told that they no longer have the profile available for additional testing. This means, according to FBI and CBI, policies, according to FBI and CBI's policies, this is not considered a match. So I'm going to go to, and this is communication between the different agencies about this 4th CODIS hit. Again, this was provided to the defense as well. So, okay. So after reading a Fox 21 News article dated March 24th, 2022, regarding an alleged possible 4th CODIS hit found in the glove box of Suzanne's Range Rover linked to a Maryland case, Agent Graham was unaware of this possible 4th CODIS match. or fourth CODIS hit. So he wanted to investigate. He first called attorney Mark Holbert the next morning, who directed Agent Graham to call Megan Doogie with the Pueblo CBI laboratory. Megan Doogie explained that the Maryland case was not a CODIS match. As part of it was a part of a keyboard search. She indicated that she had received an email from Maryland to review a possible association between the swab DNA from Suzanne's Range Rover glove box and the Maryland profile. So just for like a side note, like what is a keyboard search? I looked on FBI's website, and a DNA keyboard search is when comparative testing of a sample of DNA is used to search for other DNA profiles that have similarities. Anytime a search is performed, the CODIS software will automatically forward an alert to any laboratory involved in a possible match or association for further investigation. So that's kind of how Megan Doogie got alerted to this. A keyboard search is not a match. No arrest can be made based off a keyboard search. A keyboard search may not ever even result in identifying an unknown specimen. In order to even be a low-level, poor match, there must be at least 7 core loci, or a rarity of 1 in 10 million people that DNA exists in the population. Rather, a keyboard search is merely an investigative tool that may help investigators solve crimes based on genetic data. Does that make sense? When the offender is excluded as a contributor to the forensic unknown, the caseworker and offender laboratories shall label the candidate match as a no match, and the confirmation process stops. Banu says it shows everything was investigated with an open mind and not focused on one person. Yeah, so this is just communication between CBI agent Derek Graham and Megan Doogie, and then Mark Holbert. It's kind of like their call log or the communication log, if you... Okay, so this was done at the end of March, it looks like, March 25th. Oh, that's a different exhibit. Okay. Let me go back. So in essence, this Maryland DNA hit, which is, it's not a match, it was a dead end. So it is also eliminated. So People versus Elmar, they're the people is trying to say like this CODIS matches should not be included in the trial whatsoever because they're irrelevant. So that's kind of what that means. Let's move on to the arguments. These CODIS matches are of such limited value due to law enforcement showing the DNA in the Phoenix, Tempe, and Chicago cases are not connected in any way to the above case. It renders them irrelevant and far more prejudicial that probative. As an aside, although FBI and CBI uses the term match, in reality, they are just investigative leads. No one is arrested after a CODIS match. It is a lead that law enforcement needs to get further evidence, even for the low standard of probable cause to arrest. So again, all these documents show that the investigators followed up on these CODIS matches until they until they found the suspect, or there wasn't a suspect, or the case was closed, and things like that. So this is just kind of showing that they went the extra mile and did try to figure out these CODIS matches. So you could say that there's not a serial sex assault rapist out there because each suspect had been identified, if that makes sense, through all of this. Do I have questions on the Maryland case? Again, that one was never a match. It was a keyboard search that Maryland did, and that's when it alerted CBI in Colorado. If it had been a match, it would have been included in the May 19th letter. Was the person with the nickname Munchie near Alexandria, Indiana? No, they're in Illinois. There were two people in Illinois with nicknames Munchie, and Derek Graham followed those leads. So that case from Chicago, it wasn't really a sexual assault case because the woman who the victim, it was a consensual sex. It wasn't she was assaulted or raped. It was consensual sex that she had originally lied, but then told the truth eventually to law enforcement. That one was the Munchie case, or the Chicago, Illinois one. Someone is asking, Lauren, do you think he may have hired someone to do this for him and blamed all the missing money on Susan, but really he used it as a hit money? I don't fully understand the question. If you could kind of rephrase it. And the Tempe case, because the case was suspended when law enforcement could no longer get in touch with the victim. Doogie says this suspect can be eliminated from the unknown DNA on the glove compartment. And then the Phoenix case, the victim knew the suspect. It was her former boyfriend, and Agent Graham even collected DNA from this individual, and then that was excluded from the glove compartment. I actually went through this a lot quicker than I thought. I can talk about, I wasn't prepared for this, but I could talk about what I was going to talk about tomorrow, just briefly. So what I was planning on talking about tomorrow was what evidence that the defense want excluded and not part of the trial, and what evidence does the state want out of the trial. So I can go over kind of, the state has fewer requests than the defense. So I could talk first about what the state wants to exclude from trial, and then I can talk about that tomorrow. I just don't have a whole lot of time today to talk about both of them because there is a lot of documents that I have gotten. So this is actually the prosecution's motion in limine P45. This was filed April 5th. So the people, get to my notes. Okay. The prosecution is asking the court to limit speaking objections in the presence of the jury. So DA Linda Stanley says the defense lawyers have objected and proceeded to make argumentative and potentially inflaming statements to the court without actually listing rules based on evidentiary objections, and she's concerned it could taint or influence the jury. DA Linda Stanley wants the judge to set a procedure when objecting. And also she's asking if the court could only allow one attorney per side to litigate the issue. So in previous court proceedings, there'll be 3 defense attorneys and maybe 1 or 2 state attorneys. And so the DA Linda Stanley is asking, hey, let's just do 1 and 1. And she's also kind of requesting that the court have a procedure when it comes to objections, because she's concerned about influencing or tainting what is said to the jury when the defense or the prosecution objects to certain things in the trial. The DA Linda Stanley is also asking, get to that part, okay, if they can call witnesses multiple times when they introduce Morphew's many statements that he made throughout the investigation to law enforcement. So they're wanting, because Morphew interviewed with CBI agent Derek Graham, Joseph Cahill, FBI special agents Johnny Grusing, and Ken Harris. And so they want it to be in a chronological order rather than only having Derek Graham on the stand first and him explaining everything that he spoke to with Barry Morphew on the stand. They want it to be more chronologically ordered testimony. So they're asking, if the state is asking if they can call witnesses multiple times up to the stand to have this be more chronologically ordered as far as testimony goes when regarding Morphew's statements. And she's also saying that, you know, this will limit, like this won't, what's the word I'm looking for? It will help with the timing of the trial, and it will be less confusing to the jury, is what she's trying to say here. The other request that the people make is that, oh, this is that, sorry. Oh, so that was the argumenting, having just one attorney per side litigate that. This is, sorry, I should have scrolled down earlier. That's the part where she's requesting law enforcement, like agents with CBI and FBI, to be able to come up to the stand throughout the case, throughout the trial, to explain statements that Barry Morphew had told them throughout their investigation. Okay. Now, this is kind of giving the defense notice about if they bring up something that is relevant to, let's say, Morphew capable of harming his wife. That leads the prosecution able for them to talk about previous evidence of domestic violence cases or domestic violence acts. So this is called door be opened. So you can see that it's a doctrine. Opening the door doctrine represents efforts by the courts to prevent one party from gaining an unfair advantage by presenting evidence without being placed in the context, which creates an incorrect or misleading impression. So DA Linda Stanley is placing the defense on notice of certain impeachment of evidence should the door be opened. Specifically, so if the defense inquires through any prosecution witness or in the defense case, whether or not a witness believed Morphew was capable of harming his wife, evidence of prior acts of violence would be admissible. Also, if Morphew testifies that his marriage was without problems, evidence that directly rebuts these claims would be admissible as well. So this is where I wish I could highlight. And, oh, I guess I could. Okay. So this is what I'm talking. Ooh, wow. I'm not good at making a straight line. Ooh. Sorry, next time I will do that prior. I'm still learning how to do StreamYard. So my apologies. So we previously spoke about the CODIS hits. Prosecution is now asking that this be excluded, and they don't want any mention of CODIS hits from the glove box of Suzanne's Range Rover. And the prosecution moves to exclude any mention of unidentified alternate suspects under Elmar, and prosecution moves to exclude improper character evidence of Suzanne and prohibit. Okay, let me move on. Okay, so this is the CODIS match one is one. And I explained, if you were just now tuning in, I explained the CODIS hits in depth with each case prior to this. And so that's where I got this information, is from the attached exhibits. And then this is, they don't want any mention of unidentified alternative suspects be presented. The defense is relying on the possibility of CODIS hits to say that someone else did this. The major problem with this theory, however, is that because they are unknown, they cannot be a viable alternate suspect under Elmar. This sort of straw man approach has the danger of confusing the jury and inviting speculation. The defense is also attempting to introduce competing and confusing theories. On the one hand, they will argue to the jury that Miss Morphew was taken from the side of the road while on her bike, yet these alleged CODIS leads are taken from the glove box of the victim's Range Rover parked inside the garage at the Morphew home. Sorry, I'm about to sneeze. Okay. A defense expert will also argue that there were no signs of struggle in the Morphew home, which dismisses the idea that she could have been forcibly taken from the area by a suspect who apparently only sheds DNA in the car and not inside the Morphew residence. Further, the unknown male contributor's relation to this case is based entirely off otherwise inadmissible evidence. CODIS information is always excluded from trial because it is not definitive, and because it suggests the person's association only through propensity, that because that they have done something bad before they get in the database, they must have done something bad again. So that's kind of what they're saying, is they should just exclude. The state really just wants to exclude the CODIS match information because it will confuse the jurors, and it's irrelevant at this point. Another thing that the state wants, they want to exclude improper characterization evidence of the victim. The defense has indicated they plan to go into inappropriate character evidence of the victim, Suzanne Morphew, by their expert disclosures. So I was going to talk about tomorrow the different experts that the defense plan on presenting or having in trial. And I can go into that a little bit now. They're planning to endorse Dr. Scott Miner. He's a medical expert to talk about the alleged prescription drugs the victim had and their potential side effects. Well, his testimony is entirely based on speculation, according to DA Linda Stanley. This court has previously excluded the people from arguing that the victim was tranquilized because there's no corresponding toxicology report. This testimony is far more speculative because there's no evidence that the victim was on any medication at or around her disappearance, other than statements from Morphew. Even then, he only ever goes as far as to say that she was drunk on May 9th, 2020, although he disputes this other times, and sometimes used prescription drugs, but never discusses all of the different medication. The defense expert will open about or talk about, yeah. So this is kind of going into why they don't want the defense to talk badly about the victim. Another exclusion that the state is requesting the court do is to prohibit the defense from blanket admission of the defendant's statements as inadmissible self-serving hearsay. Okay. Then also the prosecution, let me get down to that. The prosecution is also asking the state, or the court, excuse me, to exclude Joseph Cahill's statement that he disagrees with the timing of the charges filed in this case. So talking about his opinion of when Barry Morphew was arrested. The prosecution doesn't want that or anyone else's personal opinions about the case statements that disagrees with the timing of charges filed in this case. The people believe the defense will suggest that he did not believe there was probable cause to file charges, which Stanley thinks is highly irrelevant and improper. So that's kind of why it's someone's opinion rather than keeping to the facts. For the same reason, the defense would not want Judge Murphy's opinion injected into the case. The people asked to exclude Joseph Cahill or anyone else's personal opinions about the case. Okay, do you guys have any questions? I went through a lot, so please let me know if you have questions. Yeah, so someone's asking why no limited open courts access. Are you talking about court documents or are you talking about when it goes to trial? Allie, if you could answer that, that would be great. I know that a station has requested to have live video and audio for the trial, but we're not sure if that's been denied yet. Someone's asking if there will be anything for Suzanne's birthday. That's a great question. I will have to ask some people in Salida about that because I'm not sure. I know last year they did a big balloon release, and there was a big event for Suzanne's 50th birthday. She would have been turning 51 this year at the end of April. Someone's talking about the access for people and media. I believe it's going to be first come, first serve when it comes to the trial. And they do have to have certain seats for the media. But as far as, I mean, at least this courthouse in Fremont County is bigger than the Chaffee County one. And, you know, we don't have to wear masks anymore or sit, you know, 6 feet apart or 3 feet apart from each other. So the courtroom should be allowed to have more people is what I'm trying to say. So I do have a ton more documents talking about what the defense is wanting to strike from the trial. And I will discuss that tomorrow in the evening. I work until like 7, so it will be kind of late, if that would be okay. Or please let me know if you'd rather have me do the live on Saturday morning. I can do it Saturday morning if you guys can't stay up kind of late. Is it verified there was $70,000 in the safe stolen? I haven't heard from law enforcement or that been presented in court that it was stolen. I understand that Barry Morphew had said that to investigators. Is there any documents that, you know, I didn't hold up on the screen that you want to see for a longer period of time? How many motions are still open? Oh, great question. I mean, I think the defense has filed 100 plus motions. The state has filed 50 or so motions. Some of the motions that I requested, I couldn't get because they're under seal. So I got all of April's documents that I could get, and I can show more tomorrow, obviously, or if you guys want me to do it Saturday morning, I can do it Saturday morning. Someone's asking if I can do a news story on Fox 21 and link to the entire documents. Yes, I could probably do that. Yeah. I just need time. These documents are not populated online. They're not on the cases of interest in the 11th Judicial District. They are not. Someone's asking about the witness list. Okay. I know that the state has dwindled the 500 plus names down to 173. Obviously, I'm not sure if they're going to call all 173. But that was the good standing list that they gave to the defense. And I guess I could show some other documents. Let me get that up. Because I do have more time before I do have to head out. Okay. Sorry, I'm getting the documents ready for you guys to see them. In description, can you include your sources links, please? Why are they not online? I will try to get them up as soon as I can. There's been a lot of wildfires in Colorado, and so I've been busy dealing with that, and so I can do my best and put those online. Someone's saying, I highly doubt the trial will start April 28th with the amount of motion still outstanding. Sorry if you can hear my dog. Okay, let me see if I can share my screen. Nope. Weird. Sorry for the technical difficulties. That's the wrong one. I don't know how I can go back. Someone's asking about Barry Morphew's sister seemed anxious for you to have some specific documents. Were they already public? So the court told me that the documents that Barry Morphew's sister was referring to were public, but the ones that she was giving me were not filed through the court. They weren't stamped by the court, and I didn't feel comfortable sharing those until I did get a stamped copy by the court. I believe 9 News also posted the specific documents that she was referring to. Someone's duty Ron. Thank you. Select share in the window. Okay. I found it. Sorry. Okay. So this was filed April 8th from the prosecution, and they're wanting to strike the defendant's expert witness, Dr. Richard Leo. He is a social psychologist and criminologist with a specialty in police errors that lead to non-probative outcomes in witness and suspect questioning. So they're pretty much saying that this defendant's witness, the defense failed to comply with the court's case management order. And what they say, Linda Stanley says that the defense did wrong when they wanted this expert witness to testify. Find my notes. This is, which one is he? Dr. Richard Leo. Okay. DA Linda Stanley claims the defense provided a list of 7 topics to which Dr. Leo will testify, but did not provide what his actual testimony or opinions will be. And so that's why DA Linda Stanley is saying, this expert witness shouldn't be able to testify because of that. So, and Linda Stanley is the one that's been submitting all of this. So even though she hasn't been in the courtroom, she's been really busy filing all these motions with, Mark Colbert as well, the deputy district attorney. So this is just one of many that they're wanting to strike from the defense witness list. And they're also, showing different case, Brooks versus People, giving examples. The next one is Dr. Wilson, or not doctor, sorry, John Wilson. He is a forensic scientist and criminalistics. Kind of the same thing. They're saying they failed to comply with this court's case management order. I believe these were all filed on April 8th. The majority of Mr. Wilson's testimony appears to be merely restating the evidence that will be testified to by the people's witnesses. An expert witness is not necessary to explain to the jury this information, as this does not require a scientific, technical, or other specialized knowledge, and will be merely cumulative. His testimony fails in analysis pursuant to Brooks and the Colorado Rules of Evidence, in that it is irrelevant, and even if relevant, more prejudicial than probative to the fact of this case. Oh. Someone, Duty Ron's asking, where is this document located? Is it publicly available? No. Well, it is publicly available. You have to request it through the courts. And they don't have this on the 11th Judicial Cases of Interest page where you can just download it. I will try to download all of these either to Fox 21 or to my YouTube channel so you guys can see these more in depth. Here's another one. This is Dr. Scott Miner. I had previously spoken about. Is it the case that telematics are being prevented from being used as evidence? That's something I'll talk about tomorrow or on Saturday when I do another one of these videos. The defense is trying to exclude a lot of evidence from being presented in trial, and telematics is one of them. But no ruling has been made on that. So again, the prosecution is wanting this expert witness by the defense to be struck from testifying at the trial. His name is Dr. Scott Miner. He's an expert in medical. So from earlier, it looks like he was going to testify about medication that Suzanne was on. I don't know if you guys would want me to read the document or if it would be best for me to just try to post them somewhere. So that's, I think, was that all of them? Did I say Matthew Erickson? The prosecution is also wanting to strike Matthew Erickson, who's an expert in computer forensics specialty. He specifically looked at Suzanne Morphew's HP laptop. They also want, the prosecution also wants the Dr. Philip Danielson to be struck from testifying. He's an expert in DNA, and he wrote a 6-page letter describing his testimony at trial. However, the prosecution claims the letter is not in compliance with the court case management order. Again, the people didn't receive underlying facts or data supporting his opinion. The letter lists the topics to which Danielson will testify, but does not state his actual testimony will be. Also, if he testifies, he'll give opinions regarding certain topics, but he didn't provide what the actual opinion will be. I hope that. So from my count, there's 1, 2, 3, 4, 5 witnesses that the prosecution wants to strike from the defense's list of witnesses that they have provided. Any other questions? Oh, thank you, Duty Ron. Because I'm going to have to head out. But if you guys have maybe 2 or 3 more questions I can answer, let me see if I can get off this. Okay. And again, I'm going to also do another video, so please watch out for that. I will be talking about all the evidence that the defense wants to strike from the trial, and it's a lot. And I will go into that the next video. So this video was mostly about the CODIS hits, explaining each individual CODIS hit and how that the investigators excluded those, and also the witnesses that the prosecution doesn't want the defense to call as expert witnesses. Any other questions? Let me see. Stop. Thank you guys so much for joining. I know it was kind of middle of afternoon for some people, or evening for people abroad, but thank you guys so much for joining. Okay, stop. My dog is trying to get on my lap. Yeah, so I explained, if you're just now watching, I explained the 3 CODIS matches as well as the Maryland hit. It wasn't really a CODIS match. And so I have explanations of all that with documents of police reports from each case out of Tempe, Phoenix, and Chicago that you can look at if you missed it. Yeah, if you guys want to follow me for latest information on the case when I do go to court, follow me on Twitter. It's at Lauren Scharf TV. And then also on Facebook, it's at Lauren Scharf TV as well. But I will try my best when it does go to trial April 28th I know with us not having access to computers, it's a lot more difficult. So I might have to hold off on doing YouTube videos until the very end of the night, and I might be so exhausted I might not be able to do them. But I will try my best. Oh, thank you. Again, April 28th is when the jury selection begins. So we're just a couple weeks away from the murder trial. All right, guys, I'm going to head out. Thank you guys all so much for joining. And if you missed earlier, please go back and watch the beginning. I explained, again, the CODIS matches in depth. And I will be trying to figure out where I can post these documents, either on Fox 21's website or on YouTube. And if I can do it on YouTube directly, I'll do that. If not, it will be on fox21news.com. And I will link that article to this video. Thanks so much for joining me. Bye, guys.